Good afternoon. Welcome on in. To another episode of From Day One. Today, courtesy of our good friend, Father Skeptic, we got a sub sent in court claiming you can't charge him because he was too drunk. Let's begin.
The scroll of your name, please.
My name?
Yes.
Is what you asked for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Spelled capital I, capital D, capital I, capital O, capital T. Hey guys, and welcome to today's video. Today, we have a video from a channel I watch called Time Served, who puts out regular court videos like the one we're going to watch today, which involves a sovereign citizen who not only spouts the same sovereign citizen nonsense, but also claims that he's not responsible for trespassing because he was too drunk. So if you're looking for more court content like this, then head over to the Time Served channel and check him out. A link will be in the description.
We love those folks.
So let's begin. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting Mr. Langley go. You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right, and you understand for my purposes, though that language doesn't make any sense.
Correct.
No, I do not. I understand. Okay, well, I'm telling you that, and so I am. Until you disabuse me of the motion or the notion, I am inclined to believe you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
One of Merriam-Webster's many definitions of people is a body of persons. So if you're one of the people, then by literal definition, you're a person. A dumb person, but a person. Okay, thank you. All right. So, for the record, that's my finding. Hey, hold on, we're not done.
Okay.
Yeah, you're not allowed to leave.
Have a seat.
You got it.
And thank you. Mr. Sheriff, let me swear you in. Swear the testimony and probable cause application to be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers, the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
I'm going to be completely honest with you here. This is the first time I have ever heard someone say that I was too drunk to be held responsible for my crime. Not that I didn't do the crime. Not that you don't have enough evidence to prove that I did the crime. Instead, you go with, I did it. I was just too drunk for you to punish me for doing it.
Officer advised Mr. Milton that he'd be trespassed from 7-Eleven, and he stated, I understand what you have to do. Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, can I go back in and charge it? Officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, Staff called dispatch, advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable.
Again.
And that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton, that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. Excuse me, the Nisqually jail.
On the charge
Nisqually, get it right.
of criminal trespass first degree. Is the city making a motion to revoke the deferral on the assault
Please say
conviction?
yes.
Or
Yes,
on the
sir.
assault case?
Good boy.
Based on the new law violation, yes.
Thank you. And let's see. Now, will I get a moment here to articulate anything?
Please don't.
Don't worry, you'll get your chance to shine like a burned out light bulb in a moment. Right now, the adults are talking.
I'll let you know. So since I'm still working through the process.
Of course.
All right. So, Mr. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Ms. Langley was counsel of record on that case. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That's
That
what
is
the
correct,
idiot
Your
said.
Honor. Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and
Pretty
become
good
a member
guess,
of the
Your
bar.
Honor.
Is that correct?
I can neither confirm nor deny that information, actually. I can neither confirm nor deny a sovereign citizen for, no, I don't have a law degree, but I did sleep outside of a Holiday Inn Express last night.
Outside of a Holiday Inn Express.
So, not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do, and all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Even know the right term, okay? All right, I won't appoint counsel to represent you. You'll have to represent yourself on both cases, the criminal trespass charge and the city's request to revoke the continuance and get a conviction on the assault charge. So that's at risk here with this new allegation. So I want you to be aware of that.
Whether you're stupid.
Your Honor, I was not read my Miranda rights this most recent time. I believe I'm supposed to request a voyeur of the body cams. This is one of those moments where all of the attorneys out there watching are banging their foreheads against their keyboard right now. Because an attorney, like the one sitting next to you, wouldn't know how to request discovery because it's their job to know. Just like it's their job to know that reading your Miranda rights are not a prerequisite of you being arrested, as your Miranda rights are mostly related to anything you say after you get arrested.
Like I said, I can't represent you. You're going to have to figure all that out yourself. For purposes of today,
I'll require 4 to 6 hours of unhindered internet access so that I can properly represent myself. If you would write that into a court order.
Read your form on your constitutional rights?
No.
Did I read my form? I don't believe I was provided anything.
Okay. Is there a corrections officer there?
Mr. Upton.
Yes, Your Honor.
Let's present Mr. Milton a copy of the rights form and have him read it, and then he and I can talk about it.
Yes, Your Honor. There's one taped to the desk right in front of me.
Okay, why don't you take a minute and read it? Let me know when you're done reading it. Oh.
Appreciate you. I haven't been Mirandized, so it's hard for me to even start since I can't technically be charged with anything. And there's no victim in this alleged crime.
What about those
no
people
victims except for the people that owned and operated that 7-Eleven that you refused to leave from. I'm sure they enjoyed watching your petulant behavior, and it was actually great for business to have the living man of the liquor bottle acting like a consequence-free asshole.
I know. All I'm asking right now is for you to read the rights and tell me that you have done so.
All right. Would you please silence yourself? Forgive me.
Would you please shut the fuck up and read?
And actually, Ms. Langley, if you'll unmute, because I have some questions for you regarding other cases.
Several days later.
Or we
have completed the reading, sir.
All right, thank you. I'll talk about that with you in just a moment as soon as I finish this document I'm working on.
Thank you.
Any question about those rights that are on that form?
Not particularly.
Okay, thank you. All right, so the question before the court now is whether I'm going to hold you on bail. The city has asked for $500 cash or bond on each case. Just address that issue. Don't address the underlying facts, because to the extent that you do so, any statement you say regarding that can be used against you on these cases. So right now, just address the issue of whether you should be released or not.
Appreciate you. Yes, I would like to request being released on personal recognizance, and the reason being is because there were several things articulated in the statement that were absolutely not true. For one, I was not in possession of a cell phone. No worries. I was not in possession of a cell phone, as I had my vehicle, my phone, my computer, my passport, and every physical possession stolen from me last time I was under arrest for defending a senior citizen in this community. The same day that Officer Tittle refused to search the man who stole my key.
Okay. Anything else?
That's it.
Anything else,
for now?
okay.
No. That was your one opportunity to argue against the state's recommendations to keep you in jail on 2 $500 bonds, and you did everything except make a case for yourself. So that's it for good.
Unless you would allow me to fill in some details that they failed to read me my Miranda rights.
Nope.
And I wasn't taking a statement from in both questioned cases in question.
All right. So what the case of Miranda tells us is that if you make any statements while under arrest prior to being read your Miranda rights, the prosecutor is limited in its ability to present those statements to the court. It doesn't have any other purpose other than whether something you say that can be used against you. That's the whole purpose of Miranda.
It doesn't mean they can't go forward with a
criminal charge.
I was never aware of that.
Right. Which is one of the reasons you don't want to represent yourself, but I've explained that to you now. But I just want to make sure. So you still wish to represent yourself?
Absolutely.
Okay.
All right. Seem like a sharp guy, so.
Yeah, he's about as sharp as a box of used crayons.
Appreciate you, Your Honor.
Seem dedicated to it. Okay. Based on the outstanding warrant out of Skagit County, I will hold in $500 cash or bond bail on each case, total $1,000 cash or bond. And I'll remind you, you're to have no contact with the 7-Eleven store, no criminal law violations, not consume any alcohol, marijuana, not enter any bar or tavern. And give me some realistic expectation. Are you going to be able to post bail or likely not?
If the minimum that I'm allowed to throw on a bail is $300 and I have to bail out for two things, then I'm certain I would need to acquire a phone number that I don't have in order to make that happen. And so I would have to say that it may be closer to impossible this time around.
I wonder if anybody's going to...
1 second. This guy's got to be a fucking idiot. Not saying that I, bounced in and out of corrections or anything like that. But usually, because one of my jobs in the back a long time ago, was, secretarying for a bail bondsman. Usually it's 10% of the bond is what a bail bond would charge, which in this case, $500 times 2 would be $1,000. 10% of that is only $100. I love this guy thinking it's about 6. Father Skeptic?
And tell him that his mathematical prowess is comparable to his legal acumen, because the last time I checked, 10% of 500 is 50, and 50 times 2 is 100, not 300. So in this case, if it wasn't for the legal system, then this dumbass would never get out of jail.
Okay. Well, you may know from your history that the bail here is usually 10% of what's ordered, so $50 on each case is what a bonding company would want from you. I don't know whether that
I have
changes anything. Okay, all right. Thank you. I will set this for 3 weeks from today at 1:30 in the afternoon, so on Monday the 24th of April, for what we call a pretrial, Mr. Milton. And it's a pretrial hearing. You will have received information from the city prior to that as to any offer to settle the case. Just so you know, you don't have to accept it, but they will be contacting you to give you whatever offer they have. And then you'll tell the court at that time whether you wish to accept the offer and enter whatever arrangement is made, or whether you wish to go to trial. So that'll be what we discuss on the 24th.
Awesome. In the meantime, will I be allowed 4 to 6 hours of unhindered internet access so that I can represent myself?
Yeah, I do not regulate the jail, so you're going to have to talk to the folks at the jail.
If you write it as a court order, I'm certain that they will be more likely to comply than if you don't.
All right, I'm not going to write it as a court order. Like I say, I don't mess with how the jails run their jail, but
speaking of, by the way,
Mr. Sharp has heard you, and we'll go
on a side note, if I may, Your Honor,
No, you may not.
during intake, and I might preface this with, I have gone to anti-kidnapping training.
Oh, really? You have anti-kidnapping training? Well, why don't you tell us all exactly how that's working out for you while you're kidnapped down at the county jail?
I was inhumanely subject to what I would define as torturous actions. It was by C.O. Patero. I have nothing against the man, but he only sought to escalate a situation physically that could have been de-escalated with a verbal warning, a verbal, hey, knock your stuff off, a verbal, and I was completely compliant physically, as you can see on camera if you look in holding C on the night that I was intaken. And when I was asked to be picked up and seated, they had refused and told me on their paper that they checked on me every 15 minutes when I was checked on about 3 times the first 2 hours and about twice in the last half an hour. So,
all right, we got that.
Yeah, appreciate you.
Thank you.
Yeah, so in other words, fuck off.
And we'll see you on the 24th.
Yep.
Alright guys, that's the end of the video. It looks like the next time we'll be seeing this genius is in a couple of weeks.
Alright, thank you very much, Father Skeptic. If you keep me informed of when that is, we'll be more than happy to come on back to you when that one arrives. Until then, please make sure you do like, share, and subscribe. Help get us closer to the 50,000 views, 1,000 subscribers. So, Box, you can send those nice red presents. We can send to you. And Google can put us on the algorithms. Coinbase, Ibotta, Game.gg, and a nice poker site coming to you soon. On the deal will be happening. I hope to be able to continue to provide this content on a daily basis. But, well, I'll hold that off for now. If something needs to happen, I'll post it in our channel content information. Till then, thanks for watching. Have a great day. We'll see you tonight as we continue to march along here from day one. Have a great afternoon.